Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is our podcast, I Now Pronounce You Divorced, where each week Dan, Rebecca, and I discuss topics that we see our clients going through or that we see potential clients asking us questions about. Last week, we talked about part one of estate planning during the divorce, the necessity to start protecting yourself through a power of attorney, through a medical directive, which are relatively cheap undertakings when you think about the inequities that can arise when if something happened to you and your soon-to-be ex-spouse was able to make the decision to stop life care, to go and drain your bank accounts, to do all sorts of things to you that you just don't expect. Today, we're going to talk about estate planning after the divorce. And I kind of really want to jump into where after the divorce actually starts. So this is a little bit of a weird question because on its face, after the divorce starts, after the judge signs the order. Last week, Rebecca gave us an extraordinarily great example of somebody where they went to court, they had a ruling, the judge had yet to sign the order, and then her client passed away. And so because the estate planning had not been done yet, the ex-husband, the abusive ex-husband, got all of the assets. So Dan, when you have a case where you're waiting on a judge to sign an order, let's say you have a separation agreement, some sort of a written agreement. Do you start talking about estate planning at the point the written agreement is signed, or do you try to wait till after the judge signs the order?
The attorney answer is it depends. and what I mean by that is I think both. And I say that because there are some states, for example, North Carolina, to where you could enter into a separation agreement before your divorce, but it's an agreement that can be enforced. And because in North Carolina, you have to wait a year and a day, but you have to be physically separated. But in the interim, you can go ahead and resolve all issues if you want. So then you're just really just waiting, counting down the time. And so in that situation, absolutely you can do as soon as that settlement agreement is signed. But in other jurisdictions, in other states where I'm licensed at, such as Missouri and Illinois, we don't have that benefit. I mean, you can resolve issues, but it doesn't become really enforceable until, as Rebecca mentioned, that the judge not only, acknowledges the divorce, but writes the order, signs it, and then delivers it to the parties. But then there's some other little nuances that come involved that as attorneys, we all really just love, which is the appeals. And there's a waiting period before an order becomes final. But I don't think that to answer your question, it doesn't prevent discussions from happening. I think there should be always ongoing discussions with the client as far as what does that look like. And we talked about it in the last episode. What does the future look like post-divorce? Who do you want to be if there is a situation that we have to invoke a power of attorney? What does that look like? Do you want someone just from the medical side? Do you want someone just for the financial side? Do you want someone for both? Who do you want to make the decisions? Is it a collective group that we talked about? And these are things that I just like to flush out with the clients. But then also, as we're waiting, whether we have an agreement or not, what does the bigger picture look like? Because these are discussions that are going to have to come up when you're removing somebody. You don't want to be in a position. I have a friend of mine who's in a state where we don't have an office in, or I'm not licensed in, but they're married, and they discovered that their trust has their ex-wife still on it, and their current wife, right, is a little bit frustrated and miffed by it. And so it's just these little things you don't think about become big things that Rebecca was saying that we really want to try to avoid. And that, to me, when Rebecca was saying on the other podcast, the A to Z, that is the Z part of it. What does it look like afterwards? And sometimes they can be little stressful discussions because no one likes to talk about the end of life, but it is discussions that we have to have, especially if you're going through a tumultuous divorce or even a tumultuous modification. We need to start thinking about, okay, if we have kids involved, what does that look like? If there's going to be an issue with health, what does that look like? If there's going to be any issues with that you're going to inherit it from your parents, what does that look like? Because we just want to make sure we're protecting everything. And to me, I was laughing in that episode when we were saying about estate planning is like the Biltmores having their estate. I agree. It's kind of weird when you say estate planning because a lot of us think, oh, well, I don't qualify for that. But That's not true. It's really you're planning to protect your assets. And so we probably need to come up with a better name for it. But we all need to start thinking about that and what does that look like? Because everyone works so hard, and your biggest assets are, house, retirement accounts, things like that. What can we do to make sure that those are protected, not only through the divorce process, but afterwards when either you become incapacitated or you no longer are here, so we can make sure that your legacy is living on.
Mm-hmm. Yeah, and like I said, estate planning I think is a little bit of a misnomer. You call it life planning. Proper planning prevents poor performance, as Rebecca likes.
Mhm.
Um, it can be anything, and you really have to take the mature step to say, you know what, things are going to happen that are out of my control. I need to protect these things. And, this is why we put estate planning attorneys on our staff. In every state that we practice in, we have an estate planning attorney that can help you out. I was thinking about a case that I had when I, asked when is the end of the divorce. I had a case where the client had passed away, and his ex-wife from 1984 went back, undid the divorce because of an improper service notice, invalidating his current divorce. And now she was the rightful heir to all of his estate. The client that I had who had passed away, I was technically representing his wife, his current wife. He had not done a will. He had done everything through beneficiary designations to his wife. And somehow they had worked that way just to his spouse or something like that, but they were old pensions. And now his divorce was invalidated. So his first wife that he meant to divorce was back in the picture. We fought that for years. And I was out of DC. Fought it for years. And finally the DC courts upheld the first marriage but they didn't have good law for it. They kind of just did it because they were like, this isn't right. So, Rebecca, do you want to rely on judges to say, I don't have law to back me up, but this just isn't right?
Very seldom do we see that happen. Very, very seldom do we see judges go, well, this is just what's right for this situation. This is, service of justice. There has to be some sort of foundation for it. Prior case law, an appeals case, something, something in the statute. We got to be able to cling to something in order to get to the remedy that you want to get to.
Absolutely. And, since we're talking about, we'll move past on when the divorce ends. So you've gotten divorced, Rebecca, you have children. You have children under 18. Is a will good enough?
Not at all. Not in Virginia, certainly. Other jurisdictions may operate differently, but in sort of a rough outline of how it works, my kids are 4 and 8. So if something happens to me and if I just have a will that says I want everything to go to my 4-year-old and my 8-year-old, they can't obviously take money and cash checks. They can't do it, right? So someone has to go to court and petition to be guardian over their money. And that person gets paid for their service, right? They also have to post a bond. They have to file reports with the court. They have to be smart with the money, but all of this is also costing money out of whatever you've left for the children, right? There's nobody else that's stepping in to pay these attorney's fees. It's all just coming out of the inheritance. And then once the children reach 18, they get whatever's kind of left over in the bucket at that point. We all know 18-year-olds are not super responsible with money. We've heard example after example of 18-year-old went and, bought a really fancy car and then they wrecked that car, or they went on a vacation, or, you know what I mean? They spent it unwisely. The statistics would say that a very large portion of inheritance is gone within 1 to 2 years. It's like 80 to 90% of all inherited funds are gone within that 2-year time frame. So that's not what we're going for. We're trying to build generational wealth. We're trying to give our kids a leg up in life, right? What's a better way to do that? So certainly in Virginia and in a lot of the jurisdictions where we practice, it's going to be to use a trust. So what a trust does is it lets us avoid that court process, and it lets us just choose, this is the person I want to be my trustee. They're going to manage the money on behalf of the kids, but we're not spending money on court fees. We're not having to post a bond. We're not having to file reports and do all the same sort of stuff.
So we're keeping a bigger chunk of that money for the benefit of the kids. That's number one. Number two, we can control the age when they get it. So if I don't want my kids to get the money until they turn 25, I can do that. Or I can say they get half of it when they turn 25 and they get the other half when they turn 30. I can do a certain percentage over a certain number of years. I can pay them just the interest and then they get the principal when they're a certain age. I can do all kinds of things that are not just here's a big bucket of money, now go spend it for the next 2 years until it's gone. And so there's a lot of benefit to be had from using a trust in that scenario.
And you say big bucket of money, but any bucket of money at 18. I mean, if you gave me $1,500 at 18, I probably would have bought a couple of cool pairs of shoes and some new wheels for my car.
Right.
And maybe one wheel because they're expensive. But I mean, when you have a will and you pass away, the most likely person that's going to win that contest is going to be your ex-spouse.
Mm-hmm.
All the money that you just spent in court fighting your ex-spouse, it's going back to them. And
Right.
That's why a trust is so important. Dan, can you walk us through, are trusts only for the wealthy?
No, not at all. And as Rebecca was talking, I was reminded of this article that I read a couple of days ago, to where you want to avoid probate, because a lot of clients will come in and think, oh, I don't have the money to do a trust, to go back to your question, or I don't have the money for a will. But probate is a certain percentage of your estate. And I mean, it can be substantial depending upon the value of the estate. And then the timing of it too. It could take 1 to 3 years depending upon where you're at. So, I mean, just think of everything that Rebecca was describing that we can avoid by having a trust put in place. And you have so much more control. That doesn't eliminate the process of probate, but it substantially reduces it and reduces the cost. And so I encourage any client that I speak with, if they don't have a trust, to create one. It's not hard, but we need to just have conversations as far as what are your assets, what does that look like, who do you trust, who do you want to, as Rebecca was stating, how do you want this to look like when you're no longer here? I mean, because there's so many options available. But I remember I was doing this one presentation, and the theme of it was, that you have more control over a trust than you do anything else. And you want to make sure that that control is you're protecting those assets, but you're also protecting the people that you love. And the best way to do that is to have a trust put in place. And depending upon, of course, if you have irrevocable versus revocable trust, and those are all different terms that maybe we can do another podcast on, then you just want to talk to your attorney, what is the best, because there's benefits for both. But at the end of the day, a trust, in my opinion, is for everybody, because you want to protect and you want control.
I believe the same thing. And it's not just because we have a trust package that we sell. It is because the reason we do is I think it's the best thing for most people that walk in the door. You talk about control. Control is not always, I don't trust you for the future. It can just be an acknowledgement that, let's say I have a house. Well, the house needs to be sold. And when the house is sold through probate, it's not always done the best way, versus a trust that says the house gets put in the trust. That, if I have children, the children can live there. They sell it upon this date, whatever. It's really controlling the value of your assets and not just throwing your hands up and saying, look, I worked my whole life for this, whatever it may be. And now I'm going to willingly hand it over to the state courts during the probate process. Or I'm going to let my assets just be wasted because I didn't feel like putting the effort in at the time. Or, like you said, Dana, probate could take 3 years. Yeah. You've passed away. Your family's probably not happy about that. And now you're dragging your passing away out for 3 years while they have to fight with their siblings, their aunts, their uncles. I had a case where the mother went after the child. I've had all sorts of cases that I've seen, and it just, nobody's happy. So, Rebecca, when we talk about trusts, what is the most common thing you see with a trust? Can you kind of give me an example? What's a very common trust?
So for most people, they want to provide that benefit to their kids who are underage. So anybody with minor kids is right away going to be a candidate for a revocable trust. Most of the time, they want to make sure college gets paid for or contributed to. Most of the time, they want to make sure any healthcare needs are met, that the trust can pay for living expenses up to a certain extent. And then they can inherit basically whatever's left over at the age of maybe 25, 26, something like that. I see a lot of parents structure it because they want to encourage some sort of graduate school. They want to encourage, so long as the child is in school, the tuition is paid, the books are paid, the housing and the medical, all the stuff, right, until the age of 26. So maybe you want to go ahead and get that law degree, or maybe you want to get that MBA, or maybe you want to stay in medical, something like that. It's going to encourage them to continue that because they're getting an additional benefit out of the trust. And then from there, you can really tailor it to whatever is important for you. I had a client who his mother was originally from France, and he wanted to make sure that his children could take a trip to France. And he wanted to set aside a certain amount of money to say, this is for their trip, for them to be able to do this one day. I have other clients that want to contribute towards certain music programs or language programs, or it's whatever is particular in your heart and in your family that you want to make sure you're contributing to that particular thing. A lot of people will also set aside some amount for some kind of charity that they've contributed to or has made an impact in their life. A lot of folks will also set something aside for their pets to make sure that the pets are properly taken care of. And we've seen it on the big scale where it's totally out of hand, that some multimillionaire leaves, millions and millions to a dog, and you're like, what is going on here? But it's not that unreasonable to say, I have this, dog that's probably going to live another 5 years, and I'm going to set aside $5,000 for their medical care, or, whatever it is that they might need for the rest of their life so that they can have a good life. Those are kind of some of the more common things that I've seen, but you can get so detailed with it. You can get, really down into kind of the nitty gritty and control whatever you want to control, whatever's important to you, and tailor things around that.
Mm-hmm. Yeah, I was like reading the extreme examples, where you see like, oh, this trust goes on for here, and it goes to this generation, and you end up with something like the Rockefellers, which, most people aren't. There's also another side of trust. There's a huge percentage of the population that owns businesses. Businesses, the majority of businesses are closely held organizations. So, Dan, how do you put a business in a trust, and what is the benefit of putting a business into a trust?
Those are tricky situations because you have to really discuss with the client what that business is, what does it look like, do you have a board, how is the company set up, how is it structured? There's so many different nuances, we'll say, to where before we even get to the discussion of a trust, I always want to understand what type of business it is. What are you selling? What type of service are you providing? What does the clientele look like? Are there family members that are involved in this? If not, is it just you? Do you have partners involved? What does the income look like? What is your revenue? And so I just need to go get a better understanding, and then we can determine if it goes into a trust, what type of trust is it going into, and what does that look like? Because in my experience in doing, when you have companies that would go into any type of trust, there's just so many risks involved that in the cases I've litigated, the partners didn't agree to it. And it becomes you're litigating a lot more, and going to what you were discussing earlier, you're spending a lot more money than you need to. And at the end of the day, I always like to say you're throwing good money after bad. So if it's something that is held dear to you, we need to have those discussions, what that looks like, because maybe you need to change the way that the company's operated before you can even have discussions of a trust. One of the things that I was thinking about, unrelated to your question, but as Rebecca was talking, doing a power of attorney for college students. That's one of the many benefits of a POA. A lot of times clients come in and think a POA only really comes into effect when something happens to me, but we can draft a power of attorney for your college student because you want to be able to be there if something happens, because age 18, they're considered an adult. And it could really limit your access to the information and to the data and things like that. And that's another service that I know our firm provides, but definitely encourage others who are listening to this, have discussions with an attorney to get that drafted, because you can get access to grades, you can get access when anything happens. Otherwise, you're kind of prevented and shut out from a lot. And so that's one of the positives besides dealing with anything traumatic or death that a POA can be a huge benefit for.
It can. I mean, we forget that HIPAA covers 18-year-olds. And 18-year-olds, by and large, as Rebecca said, are not the most responsible people on the planet. And, they go to college, they get mono. That's what I was, every time I went to the medical center in college, they told me I'm mono. And I'm like, I'm pretty sure it's the flu. It's not mono. But that's what they always said. And, you get sick, and now the parents can't hear anything, right? The child's sick. The child may be very sick and, out on their own for the first time. And there's the parents trying to get information from the school's medical facility, and they won't say anything. Because your child's 18 now and covered by federal laws that restrict the amount of information that can be shared. And a simple document would have helped with that. Mm-hmm. And when you were talking, I was thinking about, I just went to a new doctor. I signed a power of attorney so they could talk to my wife because I don't feel like talking about stuff. And I was like, hey, can you just get my insurance card from her? Well, it's a lot easier for me if you just do that. They're like, we need this. Like, yeah, I'll sign whatever. I don't need to read it. So probably should read it first. I like this conversation because I like breaking down the barriers of how we look at estate planning as being a stilted idea. Estate planning to me is anybody with anything that they want to make sure gets to the next generation. I don't care if it's a car, if it's a baseball card collection, you have a house with some equity in it. If you pass away at a house with equity in it and you don't have your estate plan set up, you're going to miss your mortgage payments, and your mortgage payments are going to get hit with interest and fees. And then the equity in your house is going away. So I tell anybody, if you have anything that you realistically want to get to the next generation, to anybody else, do a trust. Maybe 100 years ago, trusts were stilted, but they're not anymore. So if you or someone is going through a major life change like a divorce, talk to them about this. Share this podcast with them. Let them know that there's things that they need to do to protect themselves during the divorce, during the life change, and things that they need to do to protect themselves after the life change. And if you need any help, give Malone Hatley PC a call and see the difference that a partner will make for you. All right.
Thank you for tuning into our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.